Hello, everybody. As Professor Mortimer Sellers used to say, this IVR is a family, and it's so nice to meet you all our friends here, and I want to thank Professor Jin-Soo Kyung and her staff for this great congress and present my colleague, Claudina Orunesu, who is the vice president of the Argentinian section of the IVR and full professor at the National University of Mar del Plata in Argentina. And she will speak on rule of law, legal adjudication, and invisible law.
Thank
For
you very
yourself.
much, Marcelo. Good morning. It's a great privilege for me to be here at the antipodes of my hometown, Mar del Plata, Argentina. I thank President Malman and the IVR committee for inviting me. And of course, I also want to thank the entire host team of the Korean section that has welcomed us so well. My idea for this presentation is to offer some insights on what might be called certain standard versions or conceptions of the rule of law. More specifically, I am interested in exploring what concept of a legal system these conceptions presuppose and how this is reflected on the way we conceive judicial adjudication. Towards the end, I will focus on certain issues and certain situations that judicial adjudication faces when some pathological elements appear in legal systems. And these problems will reveal some tensions in the demands that the rule of law poses over legal adjudication. It is widely recognized that constitutional democracy, embodying the ideal of rights and the idea of self-government, is closely tied to the concept of the rule of law. There is a consensus that the ideal of the rule of law is based on the principle that power and the way it is exercised in making institutional decisions must observe certain requirements to prevent arbitrary actions. However, the specifics of these requirements and their manifestations in the legal systems of our democracies are open to various interpretations. In recent years, it has become popular three core meanings of the term rule of law based on properties deemed to be essential to it. They can be seen a certain way as three different layers of requirements, with the first of purely formal character, a second incorporating procedural requirements, and a third adding substantive constraints. So let's begin to analyze, of course, very briefly, these three layers. The first sense of the rule of law refers to the rule of law as a set of formal properties of legal systems. This is the most traditional version of the concept, where it is identified with a specific set of requirements. And in this sense, it can be characterized as a sort of technical rule or a set of technical rules directed at normative authorities. They advise on how to craft legal norms so that the law can effectively perform its function, that is to guide individual conduct. Of course, the most renowned version of this approach was offered by Lon Fuller when he defined the formal requirements of what he called the internal morality of law. For Fuller, the basic purpose of law is to govern a social group through rules. Therefore, a legal system, in order to be such and not a regime of pure arbitrariness, must at least satisfy minimal requirements. Legal system must have general norms in the sense that they have to refer to classes of actions and classes of individuals. Of course, this requirement does not preclude the existence of particular norms, but those particular norms should be created within the framework of the general norms in the form of prescriptions or power conferring norms. Furthermore, of course, the knowledge of legal norms must be accessible. There must be public to those intended to guide. Even the notion of rule following presupposes that they are known in this sense by the addressees. This same concern explains why norms should in principle be prospective and not retroactive, and also the norms should be clear because if a norm is obscure, is vague, or is ambiguously formulated, the addressee will have difficulty in understanding what the law requires of his or her, or what kind of power it grants her. The same perplexity would arise if the system contains contradictory norms, because that requires one action and the opposite and the same circumstances. And of course, a certain degree of stability, of persistence of norms over time is also necessary, because if they are frequently changed, individuals will constantly doubt what the law stipulates. I think that this set of requirements offers us a set of, a kind of catalog of practice for normative authority, and also a kind of threshold of quality conditions for the legal materials. If a system fails to meet these requirements, then we may perfectly say that this system, this legal system, is deficient. Let's take a look at the other concept of the rule of law. In this sense, we add to the previous concept procedural constraints. Therefore, we can say that in here, the rule of law is a kind of design of legal adjudication. In this point, the focus is on the role of the courts, because if we take seriously the limitations that the rule of law imposes, we must ensure that this limitation is not illusory. That is why modern legal systems provide for the existence of courts that oversee the enforcement of law, reviewing institutional decisions, in case there is a deviation from established norms. That is why we can say that courts are fundamental for ensuring or controlling compliance with the rule of law. But of course, for this mechanism to effectively serve its purpose, courts must also meet certain institutional requirements, certain procedural constraints. Courts are expected to be impartial, courts are expected to be independent from other branches of government, to ensure that judicial decision-making strictly adhere to the authority of the law. Besides, the process leading to the judicial decision-making must also reflect the idea of a limited power. That is why the exercise of jurisdiction must comply with certain requirements linked to what we may call procedural fairness. I put there some examples, like no one should be judging her own cause, or may the other side also be heard, and many more. In certain way, many of these procedural guarantees that provides the right to be heard and to present defenses and effective arguments during adjudicative processes are considered also dimensions of the rule of law in this sense. Finally, the third sense of the concept of the rule of law. Here, we add to the previous senses a third element, a third group of elements that we may call substantive constraints, where therefore we can say that in here the rule of law is considered as the legal form of constitutional democracy. There are those who argue that the rule of law cannot be reduced to a catalog of formal or procedural requirements, as we have just seen. That the idea is that the rule of law must also incorporate substantive dimensions. For example, many authors consider that the rule of law must recognize a guarantee of a certain catalog of human rights or justice or fairness. And of course, there have been objections. I mentioned there two, one was Professor Ras and the other from Professor Waldron, that may be valid concerns. And Professor Joseph Ras has argued that this approach perhaps mixes up evaluative criteria of legal system that should be distinguished. And Jeremy Waldron warns us against the temptation to overextend this concept and empty it of content. Though these normative concerns, I think, may be very valid, outside the Anglo-Saxon tradition, this debate is often evaded by distinguishing between the rule of law in its strict sense and what is called, I say it in Spanish for obvious reasons, Estado de Derecho, Stato di Diritto, or many others, or constitutional state of law, which encompasses the formal and procedural requirements already mentioned, and these substantive requirements. For example, a classical approach in this sense is the one offered by Professor Elias Diaz from Spain, when he defines the features of the Estado de Derecho as the rule of law that is an expression of the will, of the general will, and the separation of powers, and the legality of the administration, plus judicial control, and the protection of human rights. Professor Luigi Ferraioli also affirms that those states are ruled, the Estado de Derecho, those states are ruled by law, including not only the legislative, but also the substantive principles established by constitutional norms, such as the separation of powers or fundamental rights. And lately, for example, Professor Moreso has also argued that the concept of Estado de Derecho constitutes a kind of organic unity that integrates the rule of law in its strict sense, in the formal and procedural sense, with the ideal of democratic self-government and the ideal of human rights. And each of them complement each other, maximizing their value. That is why we can say in this interpretation that the Estado de Derecho, by adding substantive requirements to the previous one, can be considered the legal form of constitutional democracy. It is important to stress that these interpretations of these approaches of the rule of law, as they share a common ground of formal constraint set by the first view, assume a particular conception of the legal systems. A legal system, in this view, is seen as a set of general norms that are the product of deliberate acts of certain institutional bodies. In other words, the ideal of the rule of law in any of these approaches regards the law as a set of visible norms, a set of identifiable norms resulting from the activity, from the creative activity of legislative bodies, and differentiates very clearly between the legislative processes of norm creation and the adjudicative processes of norm application. Of course, this vision has the virtue of simplicity and allows for a quick connection with the concerns of the ideal of the rule of law. However, it overlooks important features of the functioning of legal systems that need to be considered. On one hand, it oversimplifies the process that translate certain texts, certain normative formulations, where the role of the interpreter is crucial, to certain institutional decisions. Therefore, it disregards the complexity of the activities and inputs involved in judicial decision-making, where often, together with the explicit norms, with the legislated law, another unspoken law, an invisible law created by the judges gains relevance. Sorry, we already seen that. So, the connection between the rule of law and adjudication is usually presented under a generic expression. The rule of law demands correct application of the law. This idea, for example, was noted by Fuller, for example, when referring to the various requirements of the internal morality. He stresses that the most complex of them was the congruence requirement. That is to say that the connection that must exist between what general norms demand and the institutional decision made by the courts. Ras suggests a similar idea, as you may see over there. So once the law is viewed as a tool to guide behavior, and that is necessary to have explicitly formulated norms to perform the guiding function, It follows that judges must conform to the relevant rules of the system. This idea took shape in the context of the civil law tradition, first with the rationalist natural law theory, and then later with the codification movement of the 19th century. Professor Carlos Alturon called this conception the master system conception. According to Alturon, any reconstruction of a legal system must differentiate between two concepts, between the master book and the master system. The master book is the set of linguistic entities, the normative formulations. When these formulations or set of normative formulations are interpreted and two or more interpretations result, they give rise to different master systems. So the ideal of this conception of the master system is that for each master book, there should correspond one and only one master system. That system would be the correct one. Besides, this notion of this conception of the master system also introduces certain mandates upon judicial bodies. First, these three principles are, first of all, the principle of unavoidability. According to this principle, judges must resolve all cases submitted to them within the sphere of their competence. This requirement often appears in positive norms as in the form of a prohibition against declining to decide a case. While each judge has the duty to solve only the cases within her competence, the combined competence of all judges is exhaustive. Therefore, for every possible case, there exists a competent judge obliged to provide a solution. The principle of justification tells us that any judicial decision requires a justification, a reason. And judges must state it, must explicit that justification, that reason, which cannot be freely created by them. If it is created, the justification will need, if we don't have a real reason, the decision will not be genuinely justified and will be therefore considered arbitrary. This requirement is also very often included in positive law as an obligation imposed on judges, by procedural rules. Lastly, the principle of legality. Judicial decisions must be grounded on positive legal norms. This principle complements the previous one. It demands that each decision must be justified, but the foundation should be of a specific kind. It has to be a subset of legal norms. In principle, judges should not go beyond the realm of positive law, and except in cases where the positive law itself authorizes to do it. And even in those cases, ultimate ground for the decision will be a legal norm. The principle of unavoidability responds to the practical need of the law for an effective mechanism or tool for maintaining social order. And also, it is important because when different competing objectives arise in a context of a particular case, we need an authoritative decision for the agent to know what is her obligation, what is her right. Besides the requirement of the legal, the requirement that legal decisions should be justified in positive norms is the main safeguard against an arbitrary exercise of power. While all these three principles seems sound and not very demanding, together they implicate a problematic assumption. That assumption is that judges can always find a normative basis within the legal system to conclusively resolve any case submitted to them. To use the metaphor of Professor Alturon, they assume that there is a one-to-one correspondence between the master book and the master system, and that the master system has the property of completeness and consistency. To exemplify this, to put it crudely, suppose a judge encounters a legal gap in the system of relevant norms to solve a case. Given the prohibition the prohibition of abstaining from judgment, how will she fulfill the obligation to base her decision on pre-existing legal norms? The only option will be to modify the system, but this will require an explicit authorization to modify the law. If the judge is not authorized to modify the system, the problem has no solution. Grounding a solution for the individual case without solving the system gaps violate the principle of justification. Conversely, filling the gap without authorization would violate the principle of legality, and abstaining from resolving the case would violate the principle of unavoidability. Hence, the three requirements are jointly incompatible and unsatisfiable in cases of legal indeterminacy, in cases of legal gaps, for instance. Therefore, these kind of pathological situations shows us that much of the effort to determine what it means to comply with the rule of law presupposes a rather simplistic view of the law in general and of legal adjudication in particular, and fails to address the persistent dangers that the rule of law aims to mitigate in the level of legal adjudication. According to Professor Ferraioli, in situations like this, judicial conduct may create tensions with the rule of law, affecting, among others, the principle of jurisdiction legality, the judge's subjection to the law, and of course, the separation of powers. The idea of the correct application of the law, it assumes also a minimal threshold of rationality, the deductive nature of the argumentations that ensures legal validity, the logical validity of judicial decisions. Under this view, the judges justify their decisions by constructing formally correct arguments based on the applicable laws of the legal system and the fact of the case. And this approach, of course, favors a specific type of content for the normative premises. It must be valid, positive norms. The content of valid positive norms depends on the social facts and on certain social facts and the criteria applied for interpreting and identifying norms from raw legal materials. The crucial point here is, as stated without additional specification, adherence to the rule of law relies in a view that assumes that if certain texts are drafted by legislative authorities, that is to say, if we have a master book, the transition to a single master system is easy, and we are always in position to get a master system that is consistent and is complete. That is why it may be important to evaluate what happens in the pathological situations where the law fails to fulfill the master system ideal. In cases like those, in cases where the law, because of incompleteness, because of other pathological situations, fails to fulfill one of the primary goals of the rule of law, that is to say, the ability to guide individuals' behavior, judges, and because of the principles we have already analyzed, do not simply recognize the impossibility to comply to those requirements that are placed upon them. They try to ground their decisions not on a visible law, not on explicit norms, but on an invisible law, on implicit norms that judges resort to when, in order to fulfill their duties, they issue a judgment based on this kind of norms. That is why I propose you to explore different types of implicit norms of this invisible law in order to evaluate if we can gain a better understanding of the ideal of the rule of law, and if it is possible to apply it in suboptimal situations for legal indeterminacy in the level of judicial adjudication. Let's analyze different situations where the judge makes an effort to justify her decision when the system does not provide a material for that task. The first situation number 1, refers to a norm that is a logical consequence of explicitly formulated norms. Here, the implicit norms are derived through deductive reasoning from the content of explicitly formulated positive norms, identified using interpretative criteria. Here, the explicit norms are the premises, while the implicit norms emerges as the conclusion of the implicit norm emerges from as the conclusion of the deductive reasoning. In case 2, the implicit norm is obtained through what is called legal induction, which involves transforming a plurality of norms, of explicit norms, into a more general one, often called principle. This principle is logically equivalent to the primitive norms on which it is based. This induction is feasible under the assumption that the initial explicit norms form a finite set. Here, the inductive implicit norms serves as a kind of simplification of the preexisting normative material. Case 3 is the case of a norm obtained through legal induction, but a different kind of legal induction, because it involves transforming a plurality of norms into a more general one. But here, the normative basis of the induction is not completely identified through extensional criteria. Let's imagine, for example, some natural law theories or some form of neo-constitutionalism. This approach suggests that the principle, the implicit principle, is constructed through a process of generalization that synthesize underlying norms without relying solely on their extensional definitions. In case number 4 is the case of a norm obtained from a set of explicit norms using non-deductive or logically conclusive reasoning schemes that are commonly accepted by juries, by judges, like analogical reasonings, a fortiori, a pari, enthymem's in general. Case number 5 is the case where a norm is obtained from certain dogmatic theories about positive law alone or in conjunction with other explicit or implicit norms. And by dogmatic theories here, I mean all theoretical constructions by jurists or judges that are independent from the interpretation and that uses evaluative elements in the construction of their theory. That is to say, the term theory here is used differently than in other domains because they are a kind of normative theory, sometimes disguised under a descriptive kind of dress. For example, an example of this kind of dogmatic theories would be the general theory of crime or the theory of civil liability and many others. And lastly, we have number 6, the last concept of implicit norm. where a norm is understood, implicit norms is understood as reconstruction of the underlying justification of a certain set of normative formulations explicitly issued. Uh, this the resultant implicit norm or the principle expresses values embedded within the explicit norms and establishing the underlying justification and serving as the foundation for deriving new norms. Distinguishing these various scenarios, this kind of map that we have just explored, uh, allow us to reevaluate the scope of the rule of law ideal, considering the complexities that uh, surrounds judicial decision making in real legal systems. The question that we may pose is if there is a theoretical space to continue speaking of the rule of law when analyzing adjudication in suboptimal context, or if we have to accept that it is an unattainable ideal, or if it's an ideal of a very low intensity when we speak about judicial decision making in suboptimal contexts. Um, that is why we can consider in search for answers to such questions, we may consider the possibility to develop a set of specific criteria to test the inputs used in situations like the ones uh, we analyzed before. The first criteria, the first criterion is the predictability of the normative base. This criterion refers to the ease with which the decision maker can identify the relevant materials from which the final implicit norm to conform the normative premise is elaborated. This property depends on interpretative criteria of identification. It also, this evaluation varies depending on whether only social sources are privileged or if it is possible to admit other normative realms, other norms from other normative realms, such as morality, or non-positive premises, such as the ones from dogmatic origin. The second criterion, quality of inference, refers to the kind of inference used to derivate implicit norms from an adequate normative base. Deductive inference is obviously the one of the highest quality. Uh, However, among lawyers, among jurists, it's accepted that the law often admits other types of argumentation, of non-deductive reasoning, such as the use of analogy, even in certain cases, the legal authorities authorizes that kind of reasoning. Thus, a distinction should be made between implicit norms that are obtained from deductive arguments, implicit norms that are obtained by non-deductive arguments authorized by the lawgivers, and non-deductive arguments that are validated by legal culture. Let's see coherence. Of course, as you know, the concept of coherence has many phases, has many senses. For our purposes, coherence will be interpreted as a relation between a set of explicit norms or explicit rules, and justification and the corresponding set of principles. We may say that a system of explicit rules is coherent with respect to a set of underlying principles, the justifications, if and only if the principle supports or justify all or most of the rules of the set of the rules. Coherence usually should fulfill three key functions: simplification, integration, and divisibility. The coherence will fulfill the simplification function in the cases where a system of rules can be reduced to a more fundamental or reduced based, but where the economical presentation is nevertheless logical equivalent. Secondly, the integration function consists of the possibility of deriving solutions for the system by appealing to the underlying principles. And third, the feasibility function consists of the possibility of reviewing the norms by introducing exceptions in the rules that conflicts with the underlying justifications. Lastly, the democratic deference criterion. Assuming that there is a significant connection between the rule of law and the ideal of self-governance, norms should be the expression of a democratic lawmaker. The introduction of implicit norms or principles in legal adjudication should be contrasted with the degree or its degree of deference or the degree of deference shown to the legislator. The closer and more direct is the derivation from the explicit norm, more deferent would be the implicit norm. And therefore, greater will be their congruence to the ideal of the rule of law. If we consider all these four criteria, and we go back to the different options we analyze of implicit norms, we can get something like this. Don't worry, I will not analyze all the three, all the 6 cases. But I propose to analyze 2 of them in order to see what is this problem about. Let's analyze case number 2 in the first place. As I have just said, implicit norms of type 2 are norms that are obtained through what is called legal induction from a finite set of normative formulations, from a finite set, of positive norms, explicit norms. Concerning predictability, the starting point here involves norms identified from formulations explicitly made by normative authorities. Therefore, the access is optimal. In other words, in the ideal case, it is possible to predetermine an admissible set of norms that form the normative foundations of the inductive derivation of the implicit norm. As regards the quality of the inference, here we are in front of complete induction. Therefore, the conclusion necessary follows from the premises. To evaluate the dimension of coherence, let's see an example. If a legal system includes a norm allowing all citizens to vote, and there's another norm uh, permitting all residents, regardless of citizenship to vote, uh, a, an implicit principle or norm can be inferred stating that all citizens or residents can vote. Here, the principle performs the function of simplification, uh, as it presents the same norms in a more economical way. Uh, Coherence here between rules and implicit principle is trivially satisfying in a sense, since the rules cannot fail to align with such principles abstracted from them. Finally, concerning democratic deference, to the extent that normative base is the result of the decision of a democratic lawgiver, and the implicit norm is just a more economical version and logical equivalent to, to the base, this requirement is maximally satisfied by this case. Now let's look at case number 6, the last one. Uh, in this case, we have a norm that is the implicit norm is presented as the reconstruction of the underlying justification of a certain set of rules, of explicit rules. Regarding predictability, the starting point consists again of formulations explicitly made by normative authorities. From those materials, the interpreter must identify a set of norms, and then we have to identify the underlying justifications. According to Professor Frederick Schauer, the generalizations of the included in the factual predicates limit, simplify, and specify their justifications, uh, leading to a probabilistic generalization. That is why we can talk about that we can say that a rule is over-inclusive or is under-inclusive. But in Schauer's analysis, there's something missing. There is a problem in how the reconstruction, how we reconstruct the connection between the rules and their justifications. Why? Because the enactment of a rule can be driven by multiple justifications. And even if we consider a promulgated text and we have relevant information about the context in which it was issued, it's not too easy to identify a single end, a single purpose, a single justification for that specific rule. As Professor Marmor points out, uh, around our democratic procedures, there are a lot of disagreements around. And when we realize that the various participants of this process have different ends, different purposes, it is very important to agree in one rule that has authority. Uh, there is not a one-to-one relationship between the factual predicate of the rule that constitutes the starting point and its underlying justification to ground the derivation of this type of implicit norms. In fact, for any set of rules, it will be possible to offer uh, multiple of underlying justifications. So the selection of one over the other is completely discretionary. Therefore, the predictability seemingly provided by the master book and the correlated master system is only apparent. And so this type of implicit norm is highly deficient concerning this criterion. Uh, Evaluating the quality of inference uh, from the identification of of an implicit principle understood as the underlying justification of a set of rules, new normative consequences may be derived. But the principles so understood are not obtained from the rules using deductive methods, but through the non-deductive mechanisms to achieve ampliative reasoning. This kind of ampliative reasoning can be considered at most as moderately deficient according to this criterion. Um, as regard coherence, arguments based on implicit norms may not only be adequate or enable, may not only enable the filling the gaps, but also justify solutions that conflict with the rules of the system. Therefore, they perform the function of integration, they perform the function of the feasibility. However, given what uh, we have already said, from any set of rules, it's possible to provide a multitude of underlying justifications resulting from a purely discretionary choice by the interpreter. It, Therefore, it always be possible to offer another set of implicit principles that make the set coherent. The idea of coherence will become a useless criterion of correctness that adequately connects the created implicit principle with the pre-existing explicit norms in the system. Finally, regarding the democratic deference, uh, we may say the intensity of the interpreter discretion is high, and also in these regards, the quality of the decision would be deficient. Let's go to the conclusions. Uh, Throughout this presentation, uh, I try to show that contemporary conceptions of the rule of law, perhaps in their effort to emphasize the importance of their objectives, assume an overly simplistic view of, or naive view of how our legal systems function, and particularly the process that translates certain norm formulations into institutional decisions. When the law shows indeterminacies, when the law presents pathologies such as legal gaps, uh, the ability to guide the conduct is obviously undermined. But in there, mm, our designs offer a solution. Uh, that is the idea of the principle of unavoidability. Uh, Judges must decide the cases even when the law have not given adequate materials, and in that sense, they reestablish certainty. However, uh, in pathological cases, in suboptimal cases, as we have seen, uh, the construction of implicit norms recurrent to invisible law as a solution, in many cases, may be a Trojan horse, because in certain cases, it brings in the germ of arbitrariness. Uh, to end this presentation, perhaps um, we need to make sense, in order to make sense of the ideal of the rule of law in a more complex way, we also need to make sense of the necessarily creative role of the judges when it comes to suboptimal cases. Thank you very much.